There are numerous different types of local trial courts in Texas, and many of their cases are determined by very specific issues. Number one, the Justice of the Peace courts exist in every Texas county, and the number of JP courts varies depending on the size of the county. They handle Class C misdemeanors, for example, theft of items worth less than $100 or disorderly conduct. In these cases, jail time is not a possibility, and the maximum fine is $500. The JP courts may also issue search or arrest warrants. The municipal courts, number two, have original jurisdiction over Class C misdemeanors for cases originating inside city limits, as well as cases involving municipal ordinances. These courts can also issue search or arrest warrants, but most of these courts are not courts of record, so that any appeal which is heard by the county courts are heard de novo or new, and this actually increases the expenses. That leads us to the third type of trial court. These are the 254 county courts, one county court for each county in Texas, and they are responsible for Class A, burglary or theft of property between $500 and $1,500, and Class B, DWI or possession of up to 4 ounces of marijuana misdemeanors. For Class A convictions, you can be forced to pay a fine of up to $4,000 and spend a year in jail, and with Class B convictions, the fine cannot exceed $2,000 and jail time of no more than 180 days. In addition to the county courts, the legislature is free to create what are called county courts at law, and they can have original jurisdiction that matches the county or district courts, and appellate jurisdiction from the Justice of the Peace or municipal courts. Each of these courts is created by statute, so their jurisdictions vary depending on what local legislators want to happen. In 6 large metropolitan areas, the state created statutory probate courts that are responsible for probate matters, wills, guardianship of children, and mental health commitments. Outside of these counties, the probate matters are shared with the constitutional county court or the county courts at law, depending on what decisions the state legislature has made. There are 456 district courts in Texas, and every county must be served by at least one district court. What distinguishes the district courts from the local trial courts is the original jurisdiction for all felony cases in Texas. Besides felony cases, which are criminal matters, the district courts are also responsible for civil litigation such as contested elections, divorces, land contests or money, and damages exceeding $200 in a case. Given the large backload of cases, many civil lawsuits are settled through negotiation in order to avoid lengthy delays. The bigger issue are the felonies, so rape, murder, breaking and entering, all these things are examples of felonies, and these cases, the original jurisdiction are the district courts in the state of Texas. Above the district courts are 14 courts of appeals in Texas that serve different geographic regions, and they possess appellate jurisdiction in civil and criminal cases that are appealed from the district and county courts. Figure 2 in Chapter 7 shows you a location of each of the courts, what counties they serve, and the number of judges on each court varies based on the laws created in the legislature. So the size of the courts ranges from 3 judges to 13 judges in the more populous locations. Texas is one of 2 states that have 2 Supreme Courts, and Oklahoma is the other state that handle final appellate jurisdiction. There are 9 members of the Court of Criminal Appeals, and it has discretion over which cases it chooses to hear on appeal from the Texas Court of Appeals. The only exception to this are capital punishment cases, which are automatically appealed from the district courts. They skip the Court of Criminal Appeals. They're automatically appealed from the district courts, and they automatically go to the Texas Court of Criminal Appeals. In addition, habeas corpus cases, so felony convictions where the state has to prove a reason, why someone's being held in jail, so those cases are also automatically appealed from district courts. So the Court of Criminal Appeals handles strictly criminal cases. The Texas Supreme Court is also composed of 9 justices, and it has significantly more discretion over civil and juvenile cases that are appealed from the Texas Court of Appeals. So the Texas Supreme Court looks a little more like the United States Supreme Court with significantly more responsibility over its jurisdiction. The Court of Criminal Appeals can choose which cases to hear, but it automatically has to hear habeas corpus and capital appeals. Beyond the civil cases that the Texas Supreme Court has, it also has administrative responsibilities for the legal profession in the state of Texas. For example, it approves law schools in the state of Texas and appoints the Board of Legal Examiners, which is responsible for administering the bar exam in Texas. From time to time, the Supreme Courts play an important role in policymaking in the state of Texas, as the Texas Supreme Court did in 1977 in Edgewood v. Kirby, when it ruled that big differences in rich and poor schools were unacceptable and must be corrected. So basically now for almost 40 years, going back to the court's decision, Edgewood v. Kirby, school finance is a very significant issue in the state of Texas. In general, these are courts of last resort in Texas unless an appellant, someone who's appealing the decision, can find an issue that violates some aspect of the United States Constitution. So generally speaking, most cases will end in Texas, but if the issue at stake somehow violates the United States Constitution, then you can appeal your case into the federal court system, so it's not the end of the road with either the Court of Criminal Appeals or the Texas Supreme Court. If this happens, the appellant can seek review by the U.S. Supreme Court. So, for example, one of the most prominent cases in recent memory was Lawrence v. Texas. This was a Harris County case. And in this case, the Supreme Court struck down state sodomy laws that criminalized homosexual conduct as a violation of the Due Process Clause of the 14th Amendment. Effectively, what the state of Texas had done is said that certain kinds of sexual contact are acceptable between a heterosexual couple, but they are unlawful for a homosexual couple. So in this case, the Texas Court of Criminal Appeals rejected the appeal, and Lawrence appealed it to the United States Supreme Court, and they ruled that it was a violation of the 14th Amendment, the Due Process Clause, and it represented discrimination and therefore overturned Texas law. So you have to have something along those lines. So capital punishment cases, free speech cases, anything that you might find in the Bill of Rights, the U.S. Constitution, these are all examples of cases that could theoretically be appealed from either the Court of Criminal Appeals or the Texas Supreme Court to the United States Supreme Court. But your odds of succeeding at this are relatively low.